All right, this shouldn't be a motion. Why is there a motion to reinstate bonds?
So, Your Honor, Mr. Lambkin was arrested this morning during docket on a warrant that defense was unaware of for a new case that he picked up while he was.
But did somebody,
We were preemptively trying to get ahead of it.
no, there's no need for this because it should come to me for a bond.
Okay,
So the only thing it is for the new case, is that correct?
that's correct.
All right,
Yes.
and so what is the case number on that? Because all of these are reinstate bonds and
We have 2025 CR 012 912
nine what?
912.
All right, and do you have a motion for that?
Yes, Your Honor. We have a motion to recall warrant for set bond.
Well, it's gonna have to be a bond that's set.
Okay.
So do you mind, because a bond hasn't been set, correct?
No, Your Honor. We would ask the court consider setting a PR bond based on the circumstances that this case did happen while Mr. Lambkin was in
Okay,
custody.
so based upon what he's charged with, I'm not allowed to set a PR bond, but I understand what's happening here. I think everybody understands. Do you have any objections to me, to my renaming your motion to set bond?
No, Your Honor. Thank you, Judge.
All right, so the court is aware of Mr. Lampkin's history with mental health. The court is aware that he was, he had received a bond on his other cases. He was released and that he was doing very well because he was on the correct medications. The court understands that when he was taken into custody on a warrant, he was not on his medications. That's why he ended up being taken into custody for certain alleged violations. And since that time, he has been doing very well. So is there an agreement on a bond amount?
Yes, Your Honor. I conferred with Megan and we agreed on 10,000.
Is that,
That's correct, Your Honor. And I've taken into consideration the same things at the court.
all right, so the court will set your bond at $10,000 then. And there are other previous conditions that are in the other bond. So Mr. Lambkin, I don't think they'll be able to do satellite or anything. Is that correct?
I don't believe so, Judge.
All right, so here's the thing. You have your bond set. Your attorneys will take care of it. You'll probably be released at the latest, maybe tonight at midnight if they can get everything done, or at the latest in the morning. You understand?
Good.
All right, so there is nothing to worry about. Nobody's forgotten about you. And if for some reason you're not released by tomorrow, your attorneys can come back here and we can see what's going on, all right?
Okay.
All right, do you have any questions about anything?
I know.
All right, I'm sorry this happened because you were doing very well. So sometimes things happen and we just have to handle it as they come, all right?
Good.
All right, thank you.
Judge, there's one last matter.
Mhm.
I don't know if you would prefer us to get a setting to come back later in this week once Mr. Lambkin has been released. Similar to the travel that you granted last weekend, Mr. Lambkin would like to go trick or treating with his little brother, his mother, and his grandfather this weekend on Halloween.
We'll need to, well, I understand that there are issues and that he does better when he's with his father. So if you can take, once he's released, just come back and take it up with the court.
Okay, I can do that.
And if you are unable to come back to court, if you'll discuss it with the state off docket, if they're in agreement, they'll give it to me. If they're not in agreement, we can have a hearing and we can do that hearing by Zoom because I know Halloween is almost upon us.
Okay.
All right, and Norma, just put this for October 30th because I want to make sure that he's been released.
And for plea deadline, like today, Judge, or?
Yes.
They just left it so.
Mhm. I know who it is.
I hope so, you did it.
No, the attorney is Brian Kimbrough.
Oh. Do that.
All right, the court is calling 2025 CR 008-179 State versus Paul Carpenter. Can I have parties announced?
Melissa Alvin for the state.
Robert Porter for Mr. Carpenter.
And are you Mr. Carpenter?
Yes, ma'am.
Counsel, have you received all discovery?
I have, Your Honor.
And did you review it with your client?
I did.
Court will find that the state is in compliance with discovery. Mr. Carpenter, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am, I did.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Mr. Carpenter, did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Judge, I did.
You're charged with possession of a controlled substance penalty group 1 less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea bargain agreement with the state, it appears that you're going open to the state. So the full range of punishment is open to the court. Do you understand?
Yes, ma'am, I do.
Do you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Carpenter, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am, I got.
If you're not a US citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is open. The only thing that you all have agreed to is that there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Yes, Your Honor.
Yes, ma'am.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions? Then how do you plead to the offenses charged?
I believe guilty, ma'am.
Any evidence?
State Office into Evidence States Exhibit 1.
No objection.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, all right, again, did you understand, by signing that, you're giving up your rights to a jury trial, you're giving up the rights to cross-examine witnesses and the right to remain silent?
Yes, ma'am.
So what that means is that the state is going to be presenting evidence in the form of witnesses' statements and police reports, but there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, can I reserve time to say?
Your Honor, we're asking that you impose, if not the max, something close to the max. This case is a state jail felony. However, it could have been indicted as a repeater based on his state jail repeater based on his criminal history. We could have re-indicted it. We chose not to work it out this way, or filed notice of intent to seek the enhancement. He has a very lengthy criminal history, and we think that would be a fair resolution.
And what is the criminal history?
Been convicted of interference with an emergency phone call. Failed ID. That looks like a class B failed ID. A bird cab. He did 5 years for a bird cab in 2011. Looks like there were 2 counts of that and they ran concurrently. He also was convicted of a second-degree drug case, 4 to 200. He did 30 months confinement for that. Another failed to ID fugitive, a less than a gram that he did 9 months for. Fraud use that he did 9 months for in 2018. A UUMV that he did 8 months for in 2019. Another fraud use in 2022, he did 2 years for. And several other cases that, well, a few other cases that are still pending and I think in flux, as far as I know. And I think there's reference to them in the police report that we tendered in the STIPs.
I don't know where to start, but I'm gonna start with this. It's 0.14 gram. This same district attorney's office, just a short time ago, was dismissing cases under 0.25. Now they're stepping in and asking the court to do jobs that they didn't do. Having said that, Judge, yes, he has a lengthy criminal history, but we're not here for those cases. We're here for this meth case. He's pled guilty in front of this court, and that's what he's did. He hasn't been sitting in jail doing nothing. He's been in jail actually 203 days. And what he's been doing is he took the mental health recovery program. That's number one, because as the state had pointed out to me, he at one time was considered a gang affiliated. By taking that course, he is no longer gang affiliated. That's why he's also dressed in orange. The course he took was that mental health recovery program, which helps you to handle situations, communication skills. It was AANA to get sober. They also put him on Suboxone to help him with his drug treatment. His mother right now, Judge, was going to be here today, but she had surgery on the 14th, back surgery place, so she couldn't be here. We're respectfully requesting, Judge, that we're here for a state jail felony of 0.144, and I'm not belittling that other than it's the smallest amount I've seen in a long, long time. We're respectfully requesting that this court sentence in the lower range.
All right, so I'm reading the police report, and I will tell you, Mr. Carpenter, I do consider criminal history because I always tell people criminal history is like a credit report in the sense that should I loan this person money, will they be able to pay it back? Let me look at their credit history. And criminal history is sort of like that in the sense of, should I give this probation? Should I not give them probation? What should I sentence them to? Because you look at it to see how they've done in the past, right?
Yes, ma'am.
So here's my question, and nobody's answered it. Does he have, based upon what I'm reading, are there cases that are still pending or not?
I think, Judge, well, I'll let the state go.
Sorry, that's why Rick is here, Your Honor, because those were family violence cases, and so he was gonna speak on that.
Yes, the defendant does have 2 burglary charges and a repeat BPO charge pending that unfortunately due to victim uncooperation at this time with our office, they have not yet been indicted. We are still within statute though, so at some point in the future, they may get indicted, but unfortunately doesn't appear that in the immediate future will be indicted on those.
Which is why, Judge, if I may, which is when I took over this case in the courts, I was threatened with all these cases. They have done nothing with these cases. And what they're doing now is stepping in and saying, Judge, please do the job that we can't do.
All right. All right, this is what the court is going to do. The court, as previously stated, the court is finding you guilty. The court is recommending the therapeutic community. There's to be no contact. Yeah, I thought I didn't see it. The complainant's name is not even fully in the report. So who's the complainant?
In this case, it's the state of Texas.
No.
That
I mean,
that
for
wasn't the
the-
only report, Your Honor, but since we were only proceeding on the drug case, I didn't include the entirety of the rest of the case.
And the court will sentence you to 14 months in the state jail facility and give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, yes, Judge, I did.
All right, because this is plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Judge.
All right, we can go off the record. So, Mr. Carpenter, I want to let you know that I really listened to your attorney's argument, and your attorney did make good arguments. But you are going to have to continue on the path that you're on. Otherwise, you're gonna end up right back here. You understand?
Yes, Judge.
All right, good luck to you, okay?
Yes, ma'am. Thank you.
You're welcome. Oh, no, it hasn't started yet.
When is it?
It's in November. But
That's
that's
a
a,
birthday.
yeah, but you know, I celebrate the entire month,
Okay,
so,
I try to. So.
oh, we all should. All right, the court is calling 2025 CR 010492 State versus Billy Joe Reynolds. Can I have parties announced?
Megan Galloway for the state.
Deborah Stantonberg for the defendant.
And are you Mr. Reynolds?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
And probation, this is an application. Court will find that the state is in compliance with discovery. Mr. Reynolds, did you review the application for community supervision with your attorney? Did you understand it and sign it?
I did, Judge.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading?
Yes, we waive it.
State, are you proceeding on the indictment as presented?
We're waiving the punishment.
I'm sorry, could you repeat that?
Waiving the punishment enhancements, Your Honor.
Any objection?
No, Judge.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Reynolds, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No,
Are you satisfied with the way you've been represented?
I am.
Did you understand if you're not a U.S. citizen by entering into this plea, you will be deported, denied naturalization, and re-entry?
Yes, ma'am.
All right. Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the state jail facility. There's $1,000 fine. State recommends community supervision. Did you understand that to be the plea?
Yes, ma'am.
Defense,
Yes, Your Honor.
state?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There'll be 200 hours of community service restitution, TAP evaluation, no contact with Oscar Ramirez or Jade Ward. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Did offer states 1 in attachments.
No objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
All right, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, we hope so.
Anything you wish to say on behalf of your client?
We certainly hope that you follow up our plea agreement. And my client was arrested this morning when he appeared in court. He was supposed to come Thursday. Of course, I contacted Norma
Mhm.
on Friday and asked, could I bring him Tuesday? He came today because he didn't know Court was Thursday,
Okay,
but he came when I told him.
okay. So when's the last time you've been employed?
Gainfully employed probably 2011.
All right, so what do you do? How do you support yourself?
I get a small pension from the military and also disability. I'm service connected disabled.
Okay. And so when did the drug use start?
It's been a long time ago. It was sporadic back and forth.
Mhm.
Went through treatment. It worked. Become bored after a few years and started using it again and then dropped it again.
Mhm.
Well, I quit drinking in 2000 and I hadn't picked up a drop, but it was sporadic with the drug use.
Okay. And so do you have a home to live in?
Yes, ma'am.
And the people that they say no contact, were these people that you were hanging around with?
No, the one person, no, I just barely even know him, but
Oscar, he doesn't know.
yeah, Oscar, but Jade was a personal friend, very close to.
And he hopes that you won't impose no contact because he actually helps her and her son. Like he was supposed to pick up her son from school today.
Yeah,
They're just really, really good friends. I understand that it's not in the plea agreement, it's recommended by the state. And we hope that the court will let him have contact, but order.
I'm not trying to make more work for you or her.
No, no, no. Let me just tell you the reason why I'm not going to allow contact.
Okay,
Because this is a drug case.
yeah,
I mean, you really shouldn't be picking up children from school. This is a drug case.
Right.
And, until you prove to the court that you can be clean and sober and stay
understand.
clean and sober, can't have that.
It makes sense.
Okay. All right, the court is finding you guilty. The court is going to sentence you to 2 years in the state jail facility, suspended and probated for 2 years. There's $1,000 fine to be probated. Regular reporting by Zoom or in person. Regular random UAs. Proof of employment or.
Disability.
Okay, stop.
I'm talking. Sorry.
All right. So proof of employment
Yes, ma'am.
within 45 days, or proof of your pension or retirement within 45 days. If you're not able to provide that proof, then you're going to have to get employment. There's to be no employment as a home healthcare provider or with minors. There's to be no unsupervised contact with minors. There's to be no contact with Oscar Ramirez
Mhm.
or Jade Ward. There's to be a TAP evaluation out of custody. 200 hours of community service restitution. And for every sober support meeting you complete, an hour will be deducted from your community service hours.
I'll explain to you.
Okay. That sounds
Field
good.
visits 1 time per month for 6 months. Probation, is there anything else? Is there anything else you need from the court?
No, ma'am, I think you covered everything.
All right, and Deputy Laura, you can recall the warrant. All right, did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
Oh, and probation, if you can do a referral to Veterans Treatment Court. All right, good luck to you.
Thank you, ma'am.
Oh, you're welcome.
Thank you.
You're welcome. Have a good one.
May I be excused?
Yes.
You know, I'm only chuckling because I've been here so long.
Oh, hey,
Thank you.
you're welcome.
Go to the box.